They've been broken up for a couple of weeks at this point. I do.
But Harold, if you're broken up, or should know that you're not supposed to be there, right? I can't just go to someone's car, enter the car. I know it's cold, but that doesn't give me the authority to just go in someone's car and sit in it.
Charge against the defendant for assaulting the complaining witness. So I would imagine there's not supposed to be.
Well, remember, we don't work on hunches, right? It's got to be definitive. Texas Penal Code right now.
This isn't just a breakup drama. It's a criminal trespass case that blurs the line between relationships and the law. What happens when just warming up in a car suddenly becomes a felony-level decision? Let's find out.
Person enters or remains on or in property of another, including residential land, agricultural tract, recreational vehicle, park, a building, had noticed that entry was forbidden, or received notice to depart but failed to do so. Did she have noticed that entry was forbidden?
Doesn't appear so, Your Honor. They've been broken up for a couple of weeks at this point. I do.
But Harold, if you're broken up, or should know that you're not supposed to be there, right? I can't just go to someone's car, enter the car. I know it's cold, but that doesn't give me the authority to just go in someone's car and sit in it, right?
Well, it was cold outside.
I don't care. Even if it's 100 degrees, you can't just go into someone's car.
This is a new case I had last week.
Patterson.
Yes, Misha Patterson.
Misha Patterson, yeah. This was on last.
8810.
It's set for April 3rd.
Yep, so I just noticed I didn't get a chance. You already read the probable cause before I got in here, Judge. But I noticed that I don't think it meets the probable cause. I was going to see if we could read it.
Yeah, absolutely. So you want to do a probable cause hearing?
Yes, we can.
Okay, absolutely. Please.
All right.
Did you get it? The cause number?
Yes. What is it? Criminal trespass, is that the one we're on?
Yes.
January 24, 2025, Leo dispatched to apartment regarding family disturbance. Law enforcement officer made contact with complaining witness. Complaining witness informed a dating relationship with the defendant. The defendant had been banging on door of her apartment since 1/23/25. Defendant did not make any threats or say anything besides banging on the front door. Law enforcement officer observed defendant moving around rear seats of complainant's motor vehicle. Complaining witness approached her motor vehicle, claimed ownership, and ID'd defendant as person inside. Complaining witness stated she had recently got a motor vehicle, had not let defendant borrow a motor vehicle or use it in any manner, and also stated that she secured all the seats. Defendant stated motor vehicle was already unlocked, and law enforcement officer did not observe signs of forced entry.
So just for trespass, you got to either have been warned before, don't come around here, I don't want you here, or you're there and then you're told leave and you don't leave. So this doesn't fit either one of those. I mean, the door's already unlocked in the car. She's never been told not to go in this car, stay there. In fact, this is the lady that the complaining witness was here.
And I remember that she was here.
They had a bit of a history together as well. I think there was a prior where the complaining witness.
So the trespasses were with regards to the car.
Yes.
Okay. Did the complaining witness tell her to leave and she continued to stay? Or was there some kind of notice prior that, hey, I don't want you here? Or go through it one more time, will
She
you?
did not let her borrow it or use it in any manner.
She just took the car?
She was just in the car.
She was just in the car.
It was cold that night and she was trying to get in. And I know this isn't here, but the complaint witness told me that she didn't hear the initial knocks on the door. It was later when she reviewed the Ring camera that she saw her at the door since then, but she heard at the last few, the knocks or whatever. And that's when she reviewed the camera and then called the police. But I think it was more of a situation that she wasn't sure about her mental state. I know this isn't here either, but that's what she told me.
Right, but we can't get into the facts that are out because that's not fair to them, right?
She shared with one of the prosecutors, he's not here today. I forget the young man's name. And talked to us just like with him.
Oh, with Alex?
Yeah. He did speak with her. Absolutely.
So did she tell her to get out of the car?
Well, she didn't let her in her house, which,
Right, but she's charged with the trespass of the car, right? So did she, at what point,
but she did go out of her way to say that she has never let her use the car, never borrowed it, let her borrow it in any manner.
so she's just in the car when the cops roll up?
This fact, yes. That's what I understand, having not spoken to the complaining witness myself.
How did she know that she's not supposed to be there? Because from what I understand, they're in a relationship.
Well, prior dating relationship.
How much former?
Not sure of that, Your Honor. There,
Is it something where you broke up 6 months ago and you know you're not supposed to be in the car, or is it something where it's,
there was a previous charge against the
I mean, let's look at the statute. Hold on.
defendant for stabbing the complaining witness. So
Say it again.
there's a previous
Here's the key. Trespass requires clear notice. No warning, no refusal. It gets murky. But should a past relationship automatically imply no entry? What do you think? Was this common sense, or should the law demand stricter evidence?
charge against the defendant for assaulting the complaining witness. So I would imagine that there's not supposed to be.
Well, remember, we don't work on hunches, right? It's got to be
Yes, true.
definitive. Texas Penal Code, right now.
It's 30.05, I guess.
A person commits an offense if the person enters or remains on or in property of another, including residential land, agricultural tract, recreational vehicle, park, a building, had noticed that entry was forbidden, or received notice to depart but failed to do so. Did she have noticed that entry was forbidden?
Doesn't appear so, Your Honor. They've been broken up for a couple of weeks at this point. I do.
But Harold, if you're broken up, you know or should know that you're not supposed to be there, right? I can't just go to someone's car, enter the car. I know it's cold, but that doesn't give me the authority to just go in someone's car and sit in it, right?
Well, it was cold outside.
I don't care.
It was her
Even
car.
if it's 100 degrees, you can't just go into someone's car, and just stay there as justification for criminal trespass.
Well, but I mean, we're also justifying the state filing these charges, Judge, by them not having the complete amount of the facts and the elements. As far as, just like you read, like I said at the beginning too, that no notice entry was forbidden or
Well, no,
receiving notice.
but if you're broken up with someone and you're no longer in a relationship, you can't just go into that person's car and assume that you have authority to go there, even if it's 2,000 degrees below Fahrenheit or Kelvin, right? It doesn't jive. It doesn't make sense. I don't think that would be a reasonable interpretation. If they were in a relationship, in a current relationship, then I think that would be reasonable. I think that would be okay where you could go into there, but if they're not in a relationship anymore, I think that would be, I don't think that would be reasonable, If you show me something different, then, and I'm all with it, right? But or you should know at that point, you can't just go into someone's car.
I understand, but I did check the report too, and the report mirrors this exactly. So they've got no other evidence, so they might even.
Well, Judge, she hadn't moved out, so she had taken her stuff and moved off the premises.
She had moved on.
She had moved out over a month ago.
Right, so that's what I'm saying. That adds credence to that. You can't just go into someone's car. I know it's cold. There are other places that you can go. And I don't think that that's a reasonable justification
Yeah, the month,
to violate.
I understand, the month, facts are coming from the report, and in that report, she does tell the officers, I saw stuff in there, I live here. You know, my client says that, but we might be able to work this out. I understand.
Right, but nevertheless, they had broken up, she moves her stuff out, and she may be saying that to the cop.
So the judge leans toward trespass despite no formal warning, arguing that a breakup itself should be the boundary. What's your take on this ruling? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.
Right, to be able to not get arrested, right? But what we have here is that they're no longer in a relationship. She's moved on. And yeah, I think that there's enough, you know?
Yeah.
Sorry, Harold.
Thank you.
Okay.